types of trust of the trust fall into the category of a living trust, which is an estate planning tool that people use to basically speed up the process when they pass away, and they fund it during their life. So that way, when they pass away, there's no need for a probate. So in that realm, the administration is generally the successor trustee because the first trustee is gone. And they administer it by collecting the assets of the estate, paying the debts or any obligations that the decedent may have had as the trustee, and then they distribute the property of the trust to the benefactors of the trust that's set forth in the document. So that's a general trust administration. It comes in a whole bunch of different packages, but
okay, so there's a lot going on here. I'm going to break this down a little bit.
sure.
Well, I remember before I went to law school and I sat at Creighton Law and learned about trust and estates, I always thought a trust was like a Swiss bank account or something.
Yeah.
What is an actual trust? Isn't it just a contract?
It is, that's right. And in reality, a trust is a lot like a will. It just sets forth the person, again, talking about a living trust for estate planning purposes, generally is a contract between the person who's funding the trust with their assets and the beneficiaries of that trust. And they're appointing the trustee to manage those assets, so to speak. So it doesn't have to be super complicated, and most of them are not. But it's just a fabric for distribution of that person's assets when they pass away in a general sense.
And then unlike a will where you go through probate or the court process, the trust helps keep you out of that process and therefore it's more private.
It does, that's right. And so I like to use the word, I'm not sure if this is right, but I tell people it's a little bit of a legal fiction because when you set up a living trust, you're still in charge of that trust. You fund it with your assets during your life, and 98% of them are revocable, so you can change them at any time. But because the assets are titled in the name of the trust, when you pass away, the trust owns those assets, and you do not need a probate to convey them to the beneficiaries, as opposed to you passing away and owning, let's say, a piece of real estate. It's now in your name alone if you don't put it in a trust, and you need a probate to have the judge appoint someone to have legal authority to convey the title to that asset to the beneficiaries. So that's the difference between a probate and a trust. The trust owns the assets upon your death, so title isn't necessarily in your name.
And then in a will, that person's called an executor and it goes through probate. And in a trust, that person's a trustee and the trust gets administered.
Absolutely.
Right?
Yep.
Those are the big differences.
100%.
All right. Now, who can be a trustee?
Anybody, really. It depends.
Sure.
Oftentimes in the run-of-the-mill family living trust, it usually is one of the beneficiaries, child, brother. If people are married, it's usually the other spouse, and then the last die appoints really the person who does administer it, so that's a secondary trustee. There's, to my knowledge, no major prohibitions. I've seen lawyers do it, I've seen CPAs do it. Typically, the lawyer doesn't appoint themselves as trustees, that way they're able to represent the trustee as legal counsel moving forward. So
if you're the trustee and you're somebody passes away and you know you're the trustee of that trust, how do you get started? What's the best course of action to get started?
So you usually go to the lawyer who drafted the trust.
Go to the lawyer.
That's right.
What a good answer.
Yeah. And that's important for lots of reasons, because what happens is when you take on that job, you're now a fiduciary for the other beneficiaries of the trust. And sometimes it's simple and sometimes it is not. And so the lawyer's job is to guide you through that process to make sure that you do everything correctly. In Nebraska, we have state inheritance tax. It also still needs to be paid on a trust. So you need a lawyer to do that because that's a court proceeding. So the second person you contact is a CPA because the trust still has to file final tax returns, and they work hand in hand with the attorneys. Now, I will say, really, one of the reasons why people set up living trust for estate planning purposes is it's faster upon your death. It's more private, as you said. We don't have to have public court filings like you would in a probate. And a good lawyer working well with the trustee can really get a trust administration done. And we've shot for 60 to 90 days after the date of death, and that ultimately reduces costs. So the lawyer is the first person to call. It always is. Yeah.
So if you're named as trustee, you don't need to be too concerned about it because you get to go work hand in hand with the lawyer and they'll guide you through the process essentially.
Absolutely. Yeah, the trustee really is the laboring oar. identify all the debts, collect all the assets, and the lawyer can really help guide them with any of the intricacies and make sure that they really convey the assets the way the trust says they're supposed to go, because the lawyer presumably drafted the trust and has a better understanding of the way it's supposed to go when you go in and a situation where you've misdistributed assets. So.
Now, if the lawyer didn't draft the trust, could they still come and hire you to help them through that process?
Sure, that happens a lot. It happens a lot where maybe the trustee's son has a good relationship with their attorney, personal attorney, and mom maybe wasn't that person's client. So it happens a lot. Really, the attorney-client privilege is with that trustee, or attorney-client relationship is with that particular trustee. So it's a working relationship with whoever you're most comfortable with.
And what about a bank? When would a bank get involved, maybe, or a trust department?
Mm-hmm.
In what circumstances do people tend to appoint them to be the trustee?
So we see them a lot in special needs trusts that may go on for a long period of time, and that's a whole different sort of realm that we haven't discussed here. But we do see them a lot, financial institutions appointed as trustees in trusts that may have provisions for distribution of assets over a long period of time where the living life of the trustee may not work. So minor children, we will see that, and banks and other corporate fiduciaries will act as those trustees, and they're obviously going to live longer. We also see it in situations, I see it in situations when I draft trusts for clients where maybe the person who we're drafting the trust for tells me, I'm not real sure I need any of my relatives to be involved in this. They don't get along. It's not going to work out well. So we appoint a bank or a corporate trustee to do that, and they're neutral. They abide by the terms of the trust, and we remove the emotion from the equation that way.
You bet. So there are options for folks that don't have a responsible family member that they can have fill this role. They can hire someone to serve in that capacity, and then you would work with them as the attorney. You'd work with that financial institution as the trustee.
Yep, absolutely. We've done it both ways. You do generally see it. It is usually more the relative because the financial institution will charge a little bit more for trustee's fee, but you don't want to miss the forest for the trees in that realm. And if you're able to avoid some conflict with that neutral party, it's generally cost effective in the long term. So
very good. Well, thank you so much, Andy, for breaking this all down and having a dialogue with me today on Law Talk with the Flock. Appreciate you coming on to the podcast.
You're very welcome. This was fun.
Well, thank you, everyone, and go make it worth it.
Okay. Did you guys get all of that stuff?
Yes. Started.
Yeah. So a couple of lawyers up in Nebraska, wherever that was, up north in the United States, talking a little bit about their practical day-to-day experiences with the trust. And certainly most of the things that we talked about has to do with not only the working of a trust, but certainly the involvement of a trust administrator, which is pretty much what we'll be talking about today, because it is essentially the trust administrator's job to ensure that all of those things that they were talking about and we've been talking about so far work the way they should work. Some interesting, did you guys hear anything of interest that pricked? Like made you say, interesting? Anything they said made you think like, interesting? No, I'm the only curious one in this group. What about the part of the discussion where it was said that sometimes somebody might go to a corporate trustee or a bank, for example, and say, we'd like for you to be our trustee because the family members do not get along and we don't believe that they will administer the trust properly, or they are not, in our opinion, trustworthy, and we don't want him or her or them to deal with it. Did you guys hear that part of the discussion?
Yes, I did.
Yeah. Is that a possibility, or they were just blowing in the wind?
I think that's kind of common, maybe, like to me, in my mind, I felt like that would be a common reason why people would go to a corporate entity to be a trustee.
Yeah, make no mistake about it. Every blue moon, somebody might say to a family member, I'd like you to be my trustee, in the event that something goes wrong, but not too often. And part of the reason for that is in fact, sometimes people will go to a trusted family friend or a trusted friend, personal friend of theirs before they go to a family member, because family members could be fussy. I mean, family members could be unreliable. Family members can sometimes even be untrustworthy. And depending on who is going to be the beneficiaries of the trust, the administration of that trust could run into a whole lot of problems, especially if certain people are not included in the trusteeship as a beneficiary, or their children are not going to get some of the benefits of somebody else's children, and my children, your children, their children, starts to get really weird. And so folks lose all sense of independence, and therefore the administration of the trust can run into serious trouble. Hence, settlers tend to go to corporate trustees, professional trustees, which include bankers as well, depending on the situation, okay? Law firms, trust companies, to get this thing done. All right. So I thought that was interesting. And for you youngsters who are growing into this profession and into your lives, one of these days you're going to own a little more than you own today, maybe much more depending on what happens. And so you will be asking yourself some of the same questions that we're talking about today and last week and throughout. What should I do about what I own, and so on? Who should be my trustee? Who do I trust as trustee? Should I use a personal trustee or a corporate trustee, meaning a professional trustee? All right. Bear in mind, you don't have to be rich to have a trust. If you have a $50,000 life insurance and you have a child, or not, but let's say you have a child and life insurance is as low as $50,000, you might want to appoint somebody you trust and say, I'd like you to be my trustee, and when something happens to me, that you will use the proceeds of the policy to look after my baby or my child. That is a simple trusteeship, but it's more common than you think, because unfortunately not all of us grow old and leave a big time legacy of some kind. Some of us leave a little sooner than we planned. And so it's never a bad idea, even in the real world outside of the academic context, to be aware of these things. Question: what is the difference between trust and probation? They talked about that. How are they different? If they are different, trust and probation. Anyone?
I think a probate is where you would have to take it to court, I think, where they would decide what's going to happen. That's when you don't leave a trust or a will before you die.
Correct.
And then the trust is basically where you set it up before you pass away, where you would know exactly what has to be done, or the trustee would know exactly what has to be done on your passing.
Absolutely. Couldn't say it better myself. And it's very important for persons to understand that as a matter of practice. A lot of people do not actually create trustees because they feel they cannot afford a trustee. And sometimes that is absolutely true, depending on the value of your assets. You may not be able to afford a professional trustee and perhaps don't even need one. But certainly, if that is the case, then the next best thing to do, theoretically, is to draw a will and name a trustee in the will, or two, who will then probate the will if and when something happens to you. Okay, so yeah, that's the difference between the two, and it's always a good idea to know that. The other thing that came up of interest in that discussion.
Sorry, I have a question.
Mm-hmm.
When they leave a will, I thought, are you saying that they still have to probate the will if they leave clearly states what they want to happen and they have executive estates?
You still have to probate it.
Oh, okay. That's
When
good
I
to know.
when I say probate it, the semantics of it all are not as complicated as if you don't have a will. If you have a will and your wishes are clear in the will,
Mhm.
then the process is pretty straightforward, quote unquote. If you die without a will, then of course it gets very complicated and the court involvement becomes extended and it gets a little stinky until things get sorted out. Absolutely. Okay.
So what's the purpose of them? I just don't understand the point of them probating it if everything is clearly stated out. What is it? They're just approving it then, making sure.
Yeah, pretty
Okay.
much. Yeah, it's just a formality. Okay, you make a
Okay.
presentation, the acknowledgement, and then the executive goes ahead and distribute the assets according to the will.
The will.
Okay. Now, sometimes even when you stated clearly in your will how you want things to be distributed, once the executive goes to work to distribute those assets, beneficiaries might get wind of what's going on from each other. You know, like on TV, it's like, what you get? And he said, I know what you get, and like that kind of thing. And then sooner or
Okay.
later, somebody discovers that somebody got something more, or somebody got something they felt they shouldn't have got at all, because when mommy was sick, nobody saw you. I'm the one who did all the dirty work, blah blah blah. How the hell you got the same as me? And whatever it is, gets so that can come up even with a straightforward will. And so one of the beneficiaries can end up doing what? Suing.
Taking it to court.
Yeah, taking it to court. Absolutely. And making a claim that this will is not fair. And then the judge will have to decide if they're going to consider it or not, whether there are any equity issues or not.
Okay.
Good question. Good question. All right.
So I have a follow-up question to that then.
Mhm.
So does that mean that probate versus a trust could be explained as probate, the legal title of assets is up in the air to be determined by court and other factors, whereas a trust, the legal title to assets is clear, so it can't really be challenged?
Theoretically, yes. Anything can be challenged, but theoretically, yes. That is correct.
Okay,
Okay?
thank you.
Correct. Okay. Great questions. These are very, very relevant questions, and it's very important to be as clear as you can on those issues, whether it's because of a personal matter or professionally. Either way, you still run into these issues one way or the other. Okay. Something else that came up in the discussion was something about the living trust. Did you guys hear that? The living
Yes,
trust.
I did.
Yeah. And essentially, the living trust is what?
Inter vivos.
Yeah, inter vivos, meaning that you set up a
Created it.
trust during your lifetime. You turn over the assets to the trustee, but you still pretty much control the trust until you die.
Pass away.
And then once you die, then the trustee picks up the administration of the trust in accordance with the provisions of the trust. Okay. As Tom Jones said, the attorney, living trusts are usually revocable, which means that as long as you're alive, you can take it back. Unless, of course, you declare it to be irrevocable. Once you declare that, dead, living, or in between, you cannot take it back. But as long as it's not irrevocable, then you can take it back. Okay? For sure. All right. So those are some interesting issues that came up in there as far as trust administration is concerned. And lo and behold, the trust administrator is typically the person in the trust who's responsible for making sure that these things and one million other things are done every day on behalf of the trust for the benefit of the beneficiaries. All right, but before we get to that last unit about the administrator, let's go back to 8 and see what answers you came up with for the self-assessment questions. Okay. Number 1, This is the retirement and removal of trustees. A trusted instrument may contain a blank, which allows a trustee to retire.
An express clause.
Yeah, express. Remember what we said? Whenever we see the word express, what should come to our minds first?
In writing.
In writing, of course.
I have a question though.
Yeah.
It has power clause in the first sentence, and then later on down it has express power. Is there any difference?
No difference. The only difference, I should say no difference. Technically, there's no difference. But if you want to say something about it, it's only that the power is in writing, as opposed to
Oral.
It's not expressed. Yeah, it's oral. Absolutely, absolutely. So it's like when people are dating for a long time, for example, and then Tom Jones keeps saying, we're gonna get married, and she's like, really, when? And he says, soon. I'm going to marry you, and that kind of. So he's giving an oral expression of what he intends to do until one day she gets a little fed up with it, and she says, I would like it in
Writing.
anyone in writing. And when we get married, how do we put it in writing? I mean, when we're dating, how do we put it in writing?
When we're dating?
Yeah, when we're dating, how do we put getting married in writing? How do we make it official?
Engagement.
Oh, in
Engagement.
writing,
Engagement.
the marriage certificate.
Yeah, engagement is still like oral, like talking.
Oh,
Marriage certificate.
Yeah, the marriage certificate.
say when we're
that's-
dating. Okay.
Oh,
Yeah,
then
when
you
you're
won't be dating anymore.
No, remember, yeah. Remember when you're dating, you're making all kind of oral commitments, right?
Mhm.
I will. I am. I'm sure I will. Like that. So it's an oral expression. But you're really not confirmed until it's expressed. That's why we talk about express clauses. Remember, you can create an oral trust. In case you didn't know, you could create an oral trust. But what's the problem with an oral trust? Anyone?
He say, she say. So you
Yeah,
have
he
no
say,
true
say,
proof
no,
of what was
he
said.
What's
correct.
that story?
Plus what?
Too much sides to the story.
Yeah. And then people forget and change their mouth, and somebody give them money and they change the whole story and they never witness it. Man, it goes on and on. That oral thing. Okay, oral stuff is okay, but depending what you're doing, that gets a little spooky because people forget, change their mind, and all kinds of other things. So yeah, express clauses. It should be in writing. Okay. So Tom Jones is telling me you want it in writing. You're tired of his oral expressions. All right. Number 2. What are 2 other ways in which a trustee may retire, other than the instrument?
By asking the trustees and the beneficiaries.
You can ask the beneficiaries, and if they all agree, then you can retire. Anything else?
The trustees.
The
Trustees.
What about
Trustee or trustees.
Now,
So you could,
it's the trustee who's looking to retire
Oh, under the Trustee Act.
under the Trustee Act. Yes, under the Trustee Act. And did anybody say the other one?
Or by the court.
Courts.
Oh, the courts. Yeah, you can go to the court. So if you go to the beneficiary and they said, "Man, we're not ready for you to retire yet," for whatever reason, or 4 or 5 agree and somebody disagrees for some reason. So I like that person. I don't want them to retire yet. I'm not agreeing. Whatever the reason is. So that's one option. Then the Trustee Act might make provisions. That's another one. And then if those 2 fail, let's not forget the trust instrument. The trust instrument could very well have the conditions of retirement in it. So we always start there, and we work our way down to the final authority, which is always the court. Okay? And of course, the decision of the court is final. Of course, you can always appeal a decision of the court, but it still goes to another court, which eventually becomes final anyway. But you might get a change in circumstance if you appeal. All right. Number 3, a court will discharge.
I have a question.
Mm-hmm.
So why are we excluding the trustees if it was saying that they can, if it's more than one trustee, you can, I guess, basically get permission from the trustees if they want to let you go or not, and then they could draft it up?
Oh, if it's more than one trustee?
Mhm.
Yeah, you can petition let's say there are 3 trustees. You can petition the other 2 and say to them, I would like to retire from the trusteeship. And yeah, they can agree to do that. Of course, they may not necessarily agree to do that in a vacuum. They may say, we don't have a problem with it, Jim or Mary, but let's put it to the beneficiaries and see how they feel. And then you have a beneficiaries meeting, and then have a big breakdown, and the other 2 guys say, well, we didn't have a problem before, but based on what all the griping that's going on, we have a problem now. Do you really need to retire? And then you might say, well, never mind. Or like, hell yes, I still want to retire. I don't give a flying fish what the beneficiaries say, so to speak. And then, of course, now we have an issue. And so the other 2 trustees as well, sorry, we don't want to jeopardize our relationship with the beneficiaries. We'd rather not go there now. And so what do you do next? The trustee that wants to retire, you may end up having to petition the courts and say to the court, your grace, doggone it, I would like to retire, and here are my reasons. We have had a beneficiaries meeting, they refused. The other 2 trustees initially agreed, and then after the meeting, they refused. And so we are here. I still want to retire. And so his attorney will present the evidence, and then the judge will make a decision based on that evidence.
So for question 2, trustees can be an answer.
Yeah, well, trustee can be an answer.
Okay.
It's kind of not one you see as a typical answer, but yes, it's in the case where there are what? Multiple
More than
trustees.
one. So
Yeah.
you would have to state that then. If you could use trustees, and you have to state it in the case where there's more than one trustee, they could do the deed of retirement.
Yes, you may want to do that just to make it clear.
Okay.
Because if it's one trustee, then the other issues that we discussed would apply. If it's multiple, then all would apply, including that particular point. Absolutely. All right, good to go. Man, you guys are going to be great trust people one day. All right. Number 3, a court will discharge a trustee blank, or a new trustee is capable of being appointed to the trust.
Provided there are 2 other trustees. A court will discharge a trustee provided there are 2 other trustees. For a new trustee is capable of being appointed to the trust.
Now, why do you say 2 other trustees?
2.
I mean,
It can be 1, eh?
Yeah, it doesn't have to be 2. It can be 1,
1.
even as low as 1. If they're 2, that's great.
At least 2. That's what the book say.
I think it's at least,
At least 2.
I think it's at least 2 trustees if you're doing it without going to court. But if the court is discharging you, it has to be at least 1.
Yeah, typically if 1 trustee, okay, typically. The part about it, 2 is not entirely incorrect, but 2 would just kind of be like gravy. For the purpose of the discharge, if 1 trustee is available, then they'll be fine with it. They don't make it a condition. It has to be 2 or 3. Because the idea is what? To make sure that there's at least 1 trustee available to pick up the slack. Sorry, not slack, trusteeship. All right. Number 4, a retiring trustee of a trust normally requires a blank from liability in relation to his trusteeship, which he may be granted on termination of the trust.
Release.
Release. Why would the trustee require that? Why would he request it?
So that he wouldn't be responsible for anything that happens after he leaves.
Yeah, and he could request it, and he may even be granted it under certain conditions, but even if it's granted and something illegal comes up, they're still coming after him
Yeah.
because illegalities are not considered to be in good faith in terms of being released. For example, there's no statute limitation on murder. Did you know that?
Mhm.
At least not in the US, and I suspect similarly here. There's no statute of limitation. There might be a statute of limitation for lending matters, for rape, for theft, for whatever, but not for murder. So you can be foolish enough to murder someone, and after 50 years, if they find evidence, they can come and get you wherever you are. And you cannot claim that the statute of limitations have passed, and therefore you would like for them to leave your house. They will be living with you, no matter how old you are. All right, number 5, with regards to the removal of a trustee, the court has blank jurisdiction to remove a trustee and appointing a new trustee to replace him or remove a trustee without a replacement. All has?
I'm not sure if this is right, but inherent power?
Say it again.
Inherent power? I'm not certain if that's correct.
Okay, let's see what your colleagues say. Does there anybody agree with her? Another position? She says inherent power. Anybody has another answer or the same?
I
Okay.
didn't find an answer for this one, so I
So
don't have an answer.
you were hunting around for one, but you didn't see one.
No.
Me too. I
Okay.
didn't-
Yeah,
but that
it wasn't.
sound right what she said.
Yeah, it wasn't that obvious actually. So let's find out, how did you arrive at inherent? Melissa?
1 second, let me go back to my,
Yeah, I'm sure you saw something in there that gave you that inherent
Yes.
feeling. What do you mean? Like a trustee, I'd just like to see what your thought patterns are. Don't worry, we won't disclose it to the beneficiaries. Remember, trustee minutes are exempted from disclosure. So we just want to see your thought pattern there, because that's the most appropriate answer so far. And remember, in these matters, there are not always a perfect answer for every situation. That's the next thing we need to remember as we even go about to do this job and other types of jobs. Even when matters go to court, in fact, whatever decision the courts take is not always the right decision. Sometimes courts make mistakes. The evidence is wrong. The evidence is contrived. The evidence is messed up. It's contaminated, all kinds of stuff. A lot of innocent people are gone to prison and are in there and have been murdered and hung and whatever because of decisions that were not quite right. Many people get released every day who've been in prison for 20, 30, 40 years. They discovered it's the wrong person. 40 years later, they find some DNA, and the guy who went to prison at 20 is now 60 something, and the DNA doesn't match. Let's release him. So because things go to court doesn't mean that's the perfect solution. It's just the final solution, which we hope will be the best one. Okay, Melissa, what made you think about inherent?
I can't find exactly where I got it from in my notes, but basically it just means that they have the final decision. They can make the decision, the court being the final place for you to go, and it's the final decision. They're the highest power. So basically they would let you know, or they would approve you being removed.
Well done. That is exactly what is inherent in the statements. That the answer is not direct, but that's what we derive from the fact that the courts have the final authority or the sole authority at the end to make that decision, and nobody else. once we pass through all of the other variables. Okay, good stuff. All right, number 6, the removal of a trustee by a court is normally based upon the actions of the trustee, which may be due to some blank for which he may have been formally convicted, or some blank with regards to the property under his trust, or by him becoming a blank. What's the first blank? Due to some?
Dishonesty.
Dishonesty,
Honesty, yes. Or being convicted of some?
Financial
financial
irresponsibility.
responsibility,
Indeed, indeed. And then finally becoming a
Bankrupt.
bankrupt. Anybody knows why like bankrupt is such a black mark on people's lives, including trustees? Why is that such a
Can't be
dirty word?
trusted.
That's true. Now, every bankrupt is not untrustworthy. The problem is when we hear about somebody being bankrupt, they might have become bankrupt because of untrustworthiness, but not necessarily. Sometimes because of irresponsible financial behavior.
Management.
Yes, poor financial management. So even an individual can become bankrupt because they didn't manage their financial affairs properly, or they let somebody tell them sign on the dotted line without doing the due diligence on that person in their nice suit and car and smiling sweetly about how they have a deal that they cannot refuse. Okay. I had a discussion with my 2 sons not too long ago. They're asking about different issues of life, like these kinds of things. And they said, so Dad, what happens if somebody comes with a deal you cannot refuse? I said, hang up the phone and keep moving. Does that mean that there aren't some deals in life that way? There are a few, but there are few and far between. A lot of people have become bankrupt because they've made poor financial decisions, and a lot of that is because they've been persuaded by other people. Otra gentes en español. Be careful. All right. Number 7, what are 2 other ways in which a trustee may be removed from a trust?
Unfit to act or refuse to act.
Oh, that's one. Any others? There are 2 other ones that should always come up for removal of a trustee. The trust instrument. Let's not forget
how is it
that.
a trust instrument? Okay, or by statute,
Yeah, and by statute. By statute meaning,
what?
By law.
you know, that's by courts, maybe ultimately, but by
Act,
act meaning by,
Law.
yes, by law. Whenever you have the word statute, we're talking about by law. As a matter of fact, I have a business law class that I'm teaching after you guys, and a lot of that discussion today is going to be about statutory law in terms from a business perspective. So yeah, anytime you hear the word statutory, you're thinking about the law of the land, right? For sure. Okay. Is the Constitution of the Bahamas statutory?
Run that again.
Is the Constitution of the Bahamas statutory?
Wouldn't it be? Yes.
I think so.
I'm trying to figure out if this is a trick question.
You guys you guys sound so dubious. Like, is that a trick question? Is it one of his moves again trying to get us to commit to something? And the answer is yeah, all of the above, but it's not a trick question. But I understand your hesitancy because, like anything else, when you don't do it a lot, when it's time to do it, you're a little tentative. And unfortunately, we don't talk about constitutional issues in the Bahamas much. Have you noticed that? That's one of the reasons why you're hesitant. But Believe it or not, the Constitution of the Bahamas is the highest law of the land. It supersedes every other law that we have on the books, so to speak. So if somebody comes with a law that is passed by Parliament, but it violates your constitutional rights, then you can make a case under the Constitution and say that it's not constitutional, and therefore have it removed by the court. How about that? But a lot of Bahamians don't even know they have a constitution. How about that? Not to mention what it is and how important it is to them as Bahamians. All right. So you guys have an interesting future ahead, youngsters. Ah, have fun, have a ball. All right. Number 8. A court may also remove a trustee from a trust where there is found to be blank between the trustees and beneficiaries.
Continued friction.
Yeah. Let it be known today, heretofore, that trustees and beneficiaries do not always get along, no matter how chummy they look on TV or in a particular meeting in the conference room or whatever somebody has to say about how that relationship is. That's not necessarily true. Many trusteeships have friction with regards to beneficiaries. Remember I told you beneficiaries are not always friendly. They always have a gripe, especially younger beneficiaries. The Z generation, they want everything fast and they want all they're supposed to get. Question? All right. So yeah, friction. Number 9, if trustees are blank, a discretionary trust, the court could appoint a new trustee to do so.
Unable to administer.
Yeah, unable to administer a discretionary trust. Why do we use this discretionary trust? Why is the word discretionary there? What does that suggest?
That means that they have to make the decision on how to disperse the capital or the income from the trust to the beneficiaries.
Indeed. And the reason why we say discretionary, because if it's non-discretionary, do we need a trustee per se?
No.
Not necessarily, because non-discretionary, the courts can administer it if necessary until they find a trustee. But if it's discretionary, then they will make an appointment almost immediately so that things do not get interrupted. Okay. And of course, we know that the main difference between discretionary and non-discretionary is one allows the trustee to make decisions based on their own position, perspective, experience, whatever. And the other one, you don't have any options. You do what it says. Doesn't matter if you agree or not. Some trustees have actually violated the terms of a non-discretionary trust. And when they discovered, they said, well, I did it because it wasn't fair. And the court's rule, we agree, Mr. Trustee, it was not fair as outlined in the trust instrument. However, the court reverts first to the trust instrument. And while we recognize that it was not fair, you still violated the terms of the non-discretionary trust, Mr. Trustee, and therefore you're liable, pay court fees and anything else you need to pay. Court is adjourned. Thing hits the table, that's it. Even though it was unfair. How about that? All right, number 10.
I just have something to say, like all of this just reminds you how greedy some people are for something that's not theirs.
Of course. I'm so happy you said that because we all need to be reminded of that particular fact, especially when it comes to money and assets. Man, we lose our minds. You use the word greed. Greed is the word. Then you have super greed. Then you have greed to the 90th power. Then you have greed into infinity. Absolutely. Make no mistake. Don't underestimate the power of greed. It's my foot. As if you haven't seen it in your experience yet, you will. Let's just hope that you don't become a victim of greed, somebody who's greedy, or you don't become super greedy yourself. It's a terrible thing. So yeah, thank you for that point. Okay, very important. In fact, greed is one of the main reasons why trustees have so many problems with beneficiaries. Greed is the reason why some trust relationships go to hell because trustees start getting greedy. See, the trustee starts getting greedy, like I'm the administrator of a $50 million trust, and all I get is $5 million a year in trustee fees. Man, what else can I get? It's not enough for me. I'm feeling greedier than ever, kind of thing. And then they try to do stuff. Buy trust assets in violation of the trust. Do all kinds of unethical stuff that they shouldn't do as trustee. Seek to get more fees out of the trust than they know they legally should, and so on.
I have a question based off of what you just said. Um, I'm trying to figure out how is a trustee paid? For example, you mentioned that, okay, this was a $5 million trust deed and he's only making a certain portion out of it. If they're working for a company, doesn't the company pay them, or they get like a stipend from each trust that they administer?
You mean the trustee?
Yes, the
The trustee
trustee.
gets the stipend?
Mm-hmm.
Okay, well, remember the trustee is the trust company. So
Right.
when a settler comes to Scotiabank Trust, for example, or CIBC Trust, or any trust company, they will come and say, I would like to settle my assets. And there's a grade, how much is it? 30 million. And the first thing the settler wants to know is what are your fees? Because they're shopping around for what? Lowest fees too, aren't they? Right? Well, you may
Okay.
not know that, but they are. Just like shopping for a car. Settlers shop around for trustees, professional trustees whose fees are lower than the other guy, assuming that the service is equal or similar. Okay, and so if depending on the size of the settlement, the trustee might say our fees range anywhere from 1% to 5% of the total value of the trust. And when folks pull out calculators, start doing the math, then they try to agree if that's reasonable or not. So if you have a $50 million settlement and the trustee fee is 2%, how much is 2% of 50 million per year? Anyone? Anybody else calculate it? 2% of 50 million. I know you didn't think you'd be doing any calculations. The trustees of the calculator. Anyone? $50 million times 2%. Anyone?
1 million.
How much?
1 million.
1 million. Okay, so he said, oh, 1 million a year? Mm, and then the settler will say, okay, that's fine, or not. And that's kind of how it's done. It's negotiable. There's not a standard fee. It varies by the nature and type of trust. Again, the fee will vary also because of the amount of risk involved, because some settlements carry a lot of risk, like they have expensive paintings, artwork, and all that crap. So now the trustee has to work harder to make sure that they're not stolen or destroyed by the elements or anything else. So instead of like, really, you have all that stuff in the settlement, not just money and property. I mean, real estate, great. Then we normally charge 2, but for that extra thing, we have to charge 3. And so they negotiate until they come to an agreement. But there's no standard trustee fee for all trustees, except they figure out what's going on in each other's world, and then they act accordingly. Okay, good question. This is a question that persons down the line don't really ask about because we're so busy distributing money, moving paper all day, fighting with all the operational issues. But those kinds of issues are made at the very highest level of the trustee organization, the professional trustee organization, for sure, for obvious reasons. Persons down the line don't get involved in that at all. We just get paid to do the work. All right. Number 10, did we do that? No? The circumstances surrounding the removal of a trustee under power within the trust instrument must be blank, since the power will often be strictly construed. That's what I was telling you earlier. Strictly construed for us as trustees mean that the courts will first go to the trust instrument and seek to follow it by the letter. something would have to be in that instrument that is just against humanity or real equity for the trustee, for the courts to rule outside of the instrument. For example, if one of the beneficiaries is a minor and handicapped, and the instrument says, I don't want that minor child to get anything, handicap or not, because I don't think that's my child. Well, the courts might then intervene because of the circumstances with the child. The courts might decide, I don't give a damn whose child it is. The child is a minor and they are handicapped, period. And then rule against it. But other than stuff like that, it's going to be strictly construed. Okay, and the removal of the trustee may impact that. All right, so those are the conditions. Okay, so must be
Clearly related to the power of removal.
yes, clearly related to the power of removal in the instrument. Must be clear. No ambiguity. No he say, they say, somebody said. No way. Clear. And where it's not clear, then Your Honor will make a decision, one way or the other. All right, good stuff. You guys asked some very compelling questions, and I'm glad you did, because those are some real world questions and answers that you need, especially for those of you who are actually in the world of trust and going into the world of trust. And certainly, even if you're not, we've already spoken about a lot of things that you can carry into your own personal lives. That's the beauty of this thing as well. Okay, so we're now into our final discussion about the trust administrator, the person who actually runs the day-to-day affairs from the top. And you'll soon find out now what those responsibilities are, what those duties are, and the law governing trust administration under the trust administrator. All right, and I've shouted at you guys enough for this morning. I need somebody to kick in. Should I start from the bottom or the top? Okay, this is democracy. Shall I start at the bottom or the top? No answer. Somebody say
I'll start.
something.
I'll start.
Take a chance. Who said say I'll start? Who will
Walisa.
start? Okay,
Walisa.
Melissa. Okay,
Walisa.
Melissa. Oh, Walisa. Okay, at the top. Walisa.
Yeah.
Okay, let it rip. The trust administrator.
Please excuse my background. I got some work going on outside, so let me know if it gets too noisy for you guys.
No
All right,
problem.
trust administrator. The trust administrator has the overall responsibility to carry out the administration of the trust under the direction and oversight of the trustee. Whilst the discretionary powers of the trustee may not be delegated, the trustee may delegate certain specific tasks to administrators and other agents in relation to the discretion to be made subject to the terms of the trust instrument. The exercise of the discretion by the trustees is normally shared by members of a trust committee for professional trustees whose deliberations are often documented in trustee minutes, which do not become trust property and are not required to be disclosed to the beneficiaries or a court of competent jurisdiction. The trust administrator is required to be highly trained and skilled in performing the administrative tasks of the trust. The trust administrator must also be knowledgeable of the terms of and parties to the trust. Significant reliance is placed on the trust administrator to provide the trust committee with the information needed to deliberate and decide on how, when, and to whom it will exercise its discretion, particularly in relation to any distributions to the beneficiaries of the trust. Additionally, trust administrators should understand and be knowledgeable of the trust laws governing the duties of trustees and the administration of the trust generally. The standard duty and care expected of trust administrators is a relatively high one, given their level of expertise and experience and considering their responsibilities in relation to assisting in the discharge of the trustees' duties. The trust administrator is encouraged to review the trust instrument and documents to familiarize him on the beneficiaries, their entitlements, the trustees' duties and powers generally, the appointment of agents, trustee investments, and the overall terms governing the trust. The settler's letter of wishes is also important in this review, as it provides practical guidance for the administration of the trust, although not legally binding.
Thank you very much, Elisa,
You're welcome.
for that huge introduction on the trust administrator responsibilities. As you can see, we haven't passed page 1 yet, but they have a whole bunch of things that they're responsible for doing, beginning with representing the trust company, period. Remember, the trust company is the professional trustee. The trust administrator is like the CEO of the trust company, whose job it is to make sure that things go according to schedule. And if anything goes wrong, the trust administrator will then have to give an account, just like any other CEO of anything else. Okay. So now notice she starts out with this thing about discretionary powers. We can delegate, we know now we can delegate stuff to anyone, but not our discretion. That is kept for the trustee. The trustee cannot delegate his or her discretion. That means at the end of the day, no matter what goes wrong, you are responsible. Now you can go back to the other people and try to make it right and get retribution from them if necessary, but you, the trustee, in this case, the trust administrator, will be liable, period. Okay? Also, remember, discretions are okay. They are allowed. If it's a discretionary trust, it's in the instrument and all that stuff. But then, even though they are there, we still have to make our discretions subject to the terms of the trust. In other words, we can't do things willy, bloody, nilly, so to speak. Yes, the trust instrument says that you have this is a discretionary trust, but you're still expected to act like the prudent man, see, in making a decision. And you must, as the administrator, do everything for the benefit of beneficiaries, period. That's the whole point. In very large trust companies, the trust administrator sits on the committee of other persons in the organization, maybe somebody from the legal department, the accounting department, the trust department, and all this stuff, a representative, senior management person. They sit as a committee to make discretionary decisions about how to distribute funds, how to deal with problems and issues confronting the trust itself. Okay? We know, again, it's come up again, trustee minutes are not part of trust property. Beneficiaries are suing all the time, even as we speak, to try and get access to the trustee minutes because they want to get into the what? Mind of the trustee. See what the trustee is talking about behind the discretion. And they're always suing to try and get the courts to change the position on trustee minutes. So far, they have only had very little success. There are a few exceptional cases that we can research if we want to, where the trustee minutes were deemed to be made available by a particular court on a particular petition. But they would be considered the exception and not the norm, and only the exceptions become part of case law going forward. And those exceptions are going to have to be very specific. Okay? And the fact that they're exceptional means that they have to actually be searched out and to see exactly what the exception is. Courts do not welcome petitions from beneficiaries who want to get into the trust minutes. You have to make a very compelling case. All right, it's no accident that the administrator needs to be highly trained and skilled. As you can see already, just being a trustee or working with a trust company, you need to have a certain amount of professional skill. You guys are on the way to acquiring those skills, and it's going to be extended period as you gather not only the skills, but also the experience. The academic stuff is absolutely crucial, but so is the day-to-day experience, such that when you combine them, you have what we call a highly trained and skilled trust administrator, okay? In case you were wondering. In addition to being highly trained and skilled, Felicia, what she said, you must also be knowledgeable of the terms of the parties of the trust. You need a whole lot of things going on if you are a trust administrator. Of course, trust administrators get paid huge sums of money for their efforts. And that's understandable. They have a big responsibility. Okay. But in the fact that they get paid well also means that they are sitting in a hot seat. When something goes wrong, everybody looks to them to find out what happened and what will be done to fix the problem and how quickly. Okay. So the committee is there to help the trust administrator make decisions. And then, of course, the trust administrator will make the final word based on the petitions put forth by the committee. Because at the end of the day, the trust administrator may sit in committee, form the committee, listen to the committee, but that trust administrator will be the one that makes the final decision in his or her discretion about which direction the trust will go with any particular matter. Plus, you need to know your tax trust laws and you need to know everything that governs the administration of the trust. You need to have this standard of duty and care. You can't be so busy that you forget that your primary job is fiduciary. The man, I'm too busy to think about fiduciary stuff. Well, no, you're not. Your fiduciary responsibility is more important than your ability, or let me just say equally as important. Okay? You can't be so busy and so special that you forget your prime directive, which is your fiduciary responsibility to your beneficiaries. Sometimes trustees forget. They start feeling like God doing their job. You know, like some surgeons or lawyers or whomever who get the God complex because they have performed a certain skill many times and they've become experienced. They think that the world should bow and scrape. Sometimes trustees get there and forget their responsibilities to their beneficiaries. And sometimes beneficiaries pick up on it. And this is where the friction comes in. Remember we saw in the question? And sometimes that friction even leads to what? Anybody remembers?
Going to court,
Worse than
being
that.
removed.
Yeah, with the trustee being removed. Okay, by all means. Because some beneficiaries discover in their mind that the trustee is now acting ultra vires beyond his britches. And some trustees tend to do that if they have been with if they've had a legacy trust for a long time and the things just roll in, they start to feel like, man, I'm in charge of this. I'm God of this. I'll make any decision I want. Don't tell me about the trust instrument. I know what's there. I'm doing this anyway. On it. And then things happen and they may end up losing their trust. All right, which for many trustees could be tens of millions of dollars per year. By the way, it's not a happy camper, and so trust administrator needs to be thinking about this. Let's not forget the settlor's letter of wishes. Have you guys ever heard about that?
Yes.
Yeah, what's that? What's that anyway? What is the letter of wishes anyway?
That's when the
It's where-
settler defined the way he wants the trust to be operated, run.
Yeah, it's a separate letter outside of the trust instrument. Where the settler, after his trust is settled, he has a letter of wishes that he would like the trustee to consider as he makes his discretionary decisions. Does the trustee have to adhere to the letter of wishes by the settler?
No,
No.
No.
you can use them as a
No.
guide.
Yeah, it's a guide, which is good and bad, depending on what trustee or trust administrator you have. If the trust administrator is reasonable, ethical, and all that stuff, they'll try to actually use it as a guide, especially in very important matters. But if the trustee is, you know, arrogant, disconnected, don't agree with it, I'll do what I feel like doing, the hell with it, he's dead, she's dead, they can't tell me anything but, doggone letters. But that may be your wishes, but you're dead, I'm doing what I want. Some people think like that, but not everybody. There are some trust administrators that actually look at the letter of wishes and try to follow through to the greatest possible extent. And when that happens, it's a good thing to the greatest possible extent. Okay. All right. Thank you very much, Ms. Francis. Let's see who's next on my hit list. Somebody from Melissa, are you there?
Yes, I am.
Okay, Melissa, why don't you pick up on the next page then, the trust administrator again.
The trust administrator's organization skills are critical to the effective and efficient administration of the trust. The diarizing of recurring and important events, the preparation of trust files, and the use of a comprehensive database in relation to the trust are important organizing tools for the proper functioning of the trust. Particular legal and tax opinions, changes in trust legislation, amendments to the trust, and changes to the beneficiary's circumstances must be duly noted and reviewed by the trust administrator in order to provide professional assistance and administrative support to the trustees. Equally important, the trust administrator must know and understand the investment objectives of the trust and the overall objectives of the trust. The trust administrator is instrumental in ensuring the trustees follow these investment objectives and obtain the relevant consents and approvals from any person duly appointed in the trust instrument in order to execute the investment strategy of the trust. The trust administrator is always required to discharge his administrative tasks and responsibilities within the context of the powers granted to the trustees within the trust instrument and terms of the trust generally. Another administrative task of the trust administrator is to obtain and carefully review and analyze the bank and investment statements in relation to trust assets. The trust administrator may also be required to make inquiries of bankers and investment advisors and investment managers in relation the asset holdings of the trust and in some instances inspect trust property to ensure that it is protected and preserved in accordance with the terms of the trust and generally. As the beneficiaries of a trust are required trust accounts and the decisions of the trustees that may affect their entitlements or are in response in their requests on a timely basis. The timely exercise of a trustee's discretion in accordance with the terms of the trust instrument is another responsibility of the trust administrator. Any inaction or omission on the part of the trustee in exercising his discretion as mandated by the trust instrument may result in liability for breach of trust. The trust administrator must ensure that any relevant consents or notices are required to be obtained prior to the exercise of a trustee's discretion are obtained in advance of the exercise. This task is important to avoid any liability to the trustees for any losses to the trust which may have been exercised due to the improper or invalid exercise of the trustee's discretion. Since trustees are required to account for trust property, they are mandated by law to keep financial records and accounts regarding trust property, which may be requested by the beneficiaries at any time. The trustee's duty to account is related to the beneficiary's general right to information regarding the state of trust and trust property. However, trustees may prohibit the beneficiaries from having access to information, even information they are allowed to obtain, if in their opinion to grant such access or provide such information would be harmful or detrimental to the trust.
Thank you very much, Melissa. Another mouthful. Going back again, we thought maybe after page 1, the responsibility of the administrator would taper off a bit, but instead of tapering off, it became more intense, as you can see. So even with all that stuff going on with the administrator on the first page, There are many other things, from things as simple as diarizing important events, diarizing, writing down stuff. All the trustees fail to diarize. Something comes up and nobody remembers, or they vaguely remember, or they don't recall. In fact, sometimes it's so bad it gets to court, and the court says, Mr. Trust Administrator, do you recall? And then we'd be like, back in the 80s, or back then when we had the Commission of Inquiry, and one of the persons who were called up to give evidence, says, do you recall Mr. Johnson? And he says, no. He's the West Indian guy. He says, no, I don't recall. And that actually happens in practice all the time. Part of the reason when that happens with a trustee or administrator is that they don't recall it. They keep poor records. The worst thing you can do to your organization and to your position as an administrator is to have poor records, for sure. Okay, trust files are crucial. Preparation and protection of trust files are crucial. That's all I can say. And not all trustee and trust administrators are equal in this regard, unfortunately. I've worked for one or two trust companies and consulted for a couple other smaller and middle-sized trust companies where their trust files and the whole filing system was appalling. Everything was an unholy mess, waiting for something to happen, and eventually it will. Okay, a beneficiary will call in on something, you can't find it. A court case will come up and they require evidence for the court, and you cannot find it because the trust files are in disarray. Okay? So as simple as that may seem to the administrator, that is an absolutely crucial area. And sometimes it's not always found. Legal and tax opinions, crucial. Where they filed and kept, crucial. Okay, changes in legislation, amendments, all these things. The administrator needs to be on top of the game. Anything affecting beneficiaries, especially, they take special care when it comes to beneficiaries, because they're the ones that will bring the greatest nightmare to your door, right or wrong. So if you're an administrator, anything coming up with regards to a beneficiary, you better deal with it. If a beneficiary calls you, find time to call them back as quickly as possible, because if, in the beneficiary's opinion, sometimes they feel you're taking too long to call them or respond to their email or their text, they will rain unholy hell on a particular trust administrator. And if they feel you're making it a practice for any reason, they may even get together and try to remove you as trustee for something as what we call as, quote unquote, simple as not returning their call, text, etc. That's how serious it could be. And oftentimes, with all the skill of a trust administrator, the little things as usual will drown you as an administrator if you don't pay attention. Something as simple as how you say good morning to a particular trustee can come back to haunt you because, in their opinion, you didn't say it well. You didn't say it at all. You said it grudgingly. I noticed you didn't bloody smile, Mr. Administrator. I just want you to know I'm a beneficiary. Don't piss me off. See? That's not in the text. But then a lot of human issues are not in the text. All right. My. Trust investments, absolutely crucial. Sorry, there are battles all the time about trust investments. The trustee is required to invest trust assets. In fact, the trustee administrator who sits on assets to be safe because they don't want to take any risk, so a beneficiary can file a claim in front of the courts and say they're not taking reasonable steps to increase the value of the assets. They're sitting on them. And therefore, Your Honor, we feel that we should get paid for what they should have tried to get over the last year or two. See my point? So by being conservative and not doing anything, you can be sued for that as well as a trust administrator, trustee/trustee. How about that? So in the administrator's capacity, they have to consider and check to see that the trust assets are being properly invested in the best possible and safest areas, but that it's being done. If you need to delegate and find an investment manager, do that. That's part of your delegating responsibility. But at the end of the day, you as the trustee need to follow up with the investment manager and make sure that they're making good investments. And if you feel they're not, change them to someone else. Big job trust administrator has. Of course, the trust administrator has a whole bunch of foot soldiers who help them get this job done, from the accounts department to the legal department to the trust officers and so on. All of these people are the foot soldiers for the trust administrator, who are responsible for helping the administrator get these things done. Right? So when we talk about the administrator, that's the person on top of the heap, but there are a gang of professionals below them who are supposed to and are and do have the capability. Okay. But then sometimes, you know, like the mechanic, there's a mechanic and then there's a mechanic. Trust professionals are like that too. They're not all as competent as they should be. And a lot of people don't understand that competent and capable are not synonymous. I'm sorry if you thought so. They're not. You could be quite capable, but yet incompetent, unfortunately. And we have many such persons in the trust business as we have everywhere. All right. Notice what she said in the middle of that. The administrator is always required. See, not sometimes, always, underline, always, to discharge its duties and responsibilities in the context and the powers granted to the trustees within the what? Trust instrument again. Man, those trustees who violate the instrument, they suffer the consequences all too often. And you think with that common knowledge that you wouldn't have any instances, but we still have many, many instances where trust administrators and trustees violate that particular clause for some strange reason. Why do you think that still happens? It's very clear, isn't it, students? So because it's very clear and the administrator is very experienced and capable and knowledgeable and blah, 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 why is it that we still violate it? Anybody can offer a guess? Why do we still operate outside of the instrument when we know that we should conform to it?
Sometimes we don't even know what it says.
That's true. And then that's true. That's true. Sometimes we're not familiar enough with it. We don't go back to check to see what's in it. We forget what's in it. We think we remember what's in it. See, all the above is true. That can lead to disaster, and oftentimes it does. And we are too something, lazy, busy, power struck, whatever it is, to go back and check. Now, remember when I say go back and check, you don't have to go back yourself physically as an administrator. You have all kinds of people. Call one of the lawyers in your department. Call one of your experienced trust officers. Check out the terms and conditions of this trust and send me a brief on what the key issues are. So you don't have to do it yourself, but you have to tell somebody to do it. Because a lot of times your professionals are not doing it either. Because I mean, they don't pay me to be the trust administrator. I'm not doing it on my own. And she tells me I'll do it. Even though that's really shouldn't be the position of professional either. All right. My. In addition to making sure that trust assets are being properly invested, the trust administrator must also go back and make sure that banking activity and investment activity are reasonable, truthful, and being properly disclosed by whoever's providing the information. The administrator's job never ends. As you can see, it's a 24/7 job. Despite the fact that they have tons of people working under them to get the job done, they still, doesn't matter how many people who work for you. Remember, you can delegate activity, but you cannot delegate your responsibility for the outcome. That is a fact. Some administrators forget that as well. Not to mention that sometimes we get so busy we forget that our official duty is to protect and preserve the trust. That's the other thing, because we start taking risks that we know we shouldn't take. Or maybe we don't remember anymore whether we should take it or not. And nobody bothers to consult the trust instrument, see if we should take that risk or not, to see whether the instrument gives us the authority to do that. Very interesting. In other words, like any other relationship in life, like for example, when you When you first, I like to use relationships because people start to remember. When people first get married, they're like really nice to each other. Oh, sweetheart, can you just pass that here? Oh, not a problem, darling. It's my pleasure. There it is. Anything you'd like me to do? Not at the moment, but I'll let you know if there's anything else. Okay, hon? Okay. That's the early part of the thing. Then fast forward to 7 years later. Well, we know what happens. And I tell you, give me the thing. Same thing. I mean, you know, my nerve, you got to say things twice like that. Then it starts to change. So we start taking it for granted. Trustees do that. Administrators do that. And oftentimes some of them do it to their own detriment, by the way. Same detriment that occurs in marriages. You start taking things for granted, and then somebody decides, you know what, that's the last straw. I'm not going to be taken for granted again. See you. Trustee takes it for granted, beneficiaries find out and say, you know what, see you. We're getting rid of you, Mr. Trustee or Trust Administrator, because you're taking us for granted. Doing whatever you feel like. We've told you what to do. You keep doing what you want to do and calling it your discretion. Maybe so. But we don't like it. And we don't like that you don't want to help us in what we want to do, Mr. Trust Administrator. And therefore, see, friction. Again, see that word? Friction again. Notice none of that detail is in the text. The text talks about what ought to be. But when you get in the field, you'll find out, in addition to what ought to be, some other realities. I just thought I'd throw that out. All right, so the trustee discretion is very important. But notice she said earlier, coming down the stretch, that not only do you have discretion as a trust administrator, but it has to be timed. You can't exercise your discretion when you feel like it. You have to do it in a timely, professional manner. Okay. Otherwise, if the beneficiaries feel that there's too much inaction, or you're not doing things you're supposed to do, you're omitting to do stuff, they start getting uptight with you and your discretion. And as a matter of fact, if they can prove in the court of law that you are taking too long to exercise your discretion, that there's too much inaction on your part in your discretion, and there's certain omissions in your discretion that are going on, they might petition the court and say you're in breach of trust, Miss Administrator. And depending on the evidence that's presented, the court might rule in their favor and fine you as the trust administrator, trustee. So we find you to be in breach of trust because of your untimely exercise of your discretion, your inaction. Mr. Trustee, you're not doing things in a timely manner. You're failing to do stuff you're supposed to do in your discretion, and therefore we rule in favor of the beneficiaries. Pay this amount. And be careful because they might get rid of you. Well, they may not say that, but that's a suggestion. All right. Consents and notices, again, more stuff that administrators are required to do before they act. Sometimes they do it, sometimes they don't. Sometimes they don't even feel they need to get the consents that they need to get from the beneficiaries or the protector, whoever they're supposed to get the consents from in accordance with the trust instrument again. Because we start taking things for granted in our discretion. To say discretion is like freedom. When you have a non-discretionary trust, you don't have the freedom to make any decisions. You do what it says. So that minimizes the problems potentially. But the moment people get to exercise their discretion, it's like being freed, quote unquote. And sometimes freedom can cause us to hang ourselves, as it causes some trustees to hang themselves when they have to administer our discretionary trust. Because they start getting the God complex and God knows what other diseases that can, in fact, affect an administrator / trustee, that can lead to major fines, major friction, and their demise as far as their trusteeship is concerned over a particular trust. Okay? Wow. Big job, this trust business. But of course, the trust business is a multi-trillion-dollar business. Legacies all over the world, from the filthy rich all the way down to regular folk. Okay, so this is big business. All right. So we're now down to the final conflict. Let's see who's going to. Janice, are you there?
Yes, I am.
Wonderful. Then you can take us out to the end of this trusteeship responsibility. Sorry, trust administrator responsibility. Please, if you're thinking about being a professional trustee one day, and even a trust administrator, but perhaps don't let this stuff cause you to panic. It only becomes a problem when you fail to do what you're required to do. Okay, that's really the point. If you're very interested in doing what is required, then it can be an amazing thing. But if you get into that mode where you start wanting to do what you want to do, like anything else, it's going to create an unholy mess somewhere. Okay, Janice, since section 83.
Since Section 83 of the Trustee Act 1998, 1998, allows beneficiaries to inspect trustees, accounts, and other trust documents, except trust minutes, the trust administrator must ensure that such documents are properly presented when requested and are organized in the appropriate trust files. This action is also very important in the event that the trustee is asked to give information on the administration of the trust, as may be required by the beneficiaries or the court. The trust administrator must also take special care to ensure that amendments to the trust instruments are done in accordance with any express powers reserved within the trust instrument to do so, or any other method prescribed. The amendment to the trust instrument must be clear and unequivocal, and the trust administrator should ensure that all changes to be made in the administration of trust, example changes in beneficial entitlements, consents, etc., due to the amendments made to the trust instruments are duly noted. The trust administrator should not only protect and preserve trust property due to the proposed amendments, but also ensure that the legal protections and remuneration of the trustee are not adversely affected. He must also take care that the proposed amendments are not contrary to existing law, create additional responsibilities, or increase the risk exposure of the trustees without adequate legal protection or increased remuneration. Not only should the trust administrator ensure that the legal formalities to effectuate the amendment are recognized and executed, but he must also take action in carrying out any or all duties that may assist in the efficient functioning and effective administration of the trust subsequent to the amendment.
Thank you very much. So now we see with all the other blah, 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 there are more stuff all the way to the very end. Take note that Section 83 of our Trustee Act of 1998 makes certain allowances for beneficiaries except trust minutes again. That doesn't mean that the courts cannot rule on exception basis, but generally no. Notice I said it earlier, those files have to be in order, and now we see why. When these matters come before the courts, for example, the documents must be properly presented, organized, in order. They are not all that way. Don't presume they are, okay? For sure. Notice the special reference to organized files. So this becomes especially important when these documents may be required by two crucial groups to the administrator. Who are they? What are those two groups?
The beneficiaries or the court.
Yeah, the beneficiaries or the court, the usual suspects. They are the two that will create a nightmare for any administrator / trustee. If you want to figure out already, even at this early stage in your life with this thing, just know that your prime directive must be to satisfy these two groups, even though they operate from different angles. You should always want to know that your beneficiaries are being satisfied to the greatest possible extent. Does it mean that everything you do will satisfy them? No. Does it mean that you should do anything to satisfy them? Hell no. It just means that you should do everything reasonable to satisfy them. And if they're not satisfied with something, they're free to go to the next guy called the court. But administrator always wants to be wary of the court. You only want to go to court if you have to. You only want somebody to take you to court if you can't help it. Okay, for sure. God forbid the discussion on amendments. When we start talking about amendments, we're talking about changing stuff, especially when we're talking about amendments to the trust instrument. We're not just talking about an amendment to some trust minutes or some other consent document. Hell no. We're talking about the trust instrument. That means the minute the decision is taken for whatever reason to make any amendments to a trust instrument, all the protocols must be documented and recognized and followed to the T. Otherwise, eventually, whatever that amendment is will come back to be a nightmare for the administrator. May even cost you your job, may even cost the trustee the trust. Okay? For sure. Notice we are told very clearly, amendments must be clear, not long legal mumbo jumbo. Well, we probably still have some of that. But in any event, if it's legal mumbo jumbo, it should be clear legal mumbo jumbo, whatever that is. And it must be unequivocal. Anybody knows what that means? What do you mean by it has to be unequivocal? What does that mean? Unequivocal means there should be no doubt in the substance of the amendment. No ambiguous language that suggests two different things in one that can create doubt in anybody's mind about what that amendment is supposed to be. Okay? It's like if you ask somebody, do you love me? And you say, well, it's kind of, sort of. Can anybody tell me what kind of, sort of is? Any of you ladies? Can you tell me what kind of, sort of? Is that yes or no?
I mean, sure.
Is that true? Unsure. Is it yes or no?
Sitting on the fence,
Sorry?
sitting on the fence to go, it could be either way.
Yeah, it's neither yes nor no, which is the worst condition ever. Correct? Even the Bible says that God hates ambiguity. See? Hates it. It says it very clearly, and he's God. Imagine us down here, no, we do. So when we talk about unequivocal amendments, we mean it has to be clear, no doubt, no on the fence, no kind of, sort of an amendment. Hell no. It's one or the other. Okay? Very clear. And I suspect if the Bible says don't be unequivocal, then there must be some substance. If you're going to be the devil in hell, be that. If you're going to be that person's going to do the right thing, be that. But that equivocal thing, that is always spooky, no matter whether it's a trust environment or anywhere else. All right. I made a little drumbeat on that because sometimes amendments are made that are equivocal, but you don't realize it's equivocal until it gets to a court case or gripe by beneficiary, and then all of a sudden, when everybody looks at it again, when the QC lawyers look at it, and all the other lawyers and the other lawyers look at it, they see all kinds of, Your Grace, upon review of the amendments to this trust, we have come across several ambiguities. See, then all hell breaks loose. And nobody really realized that unless something happens. Very important clause in there about how to treat amendments to the trust instrument. Because an amendment to trust instrument is not like an amendment to any other trust document. Remember, the trust instrument is the highest power in the relationship. So high that even the courts are not interested in changing any of its conditions unless it's an extreme situation. And when I say extreme, I mean extreme. Has to be a seriously inequitable case. Case that can have far-fetched repercussions if an adjustment is not made. But other than that, hell no. The judge will sit back and say, excuse me, lawyers, what does the instrument say? Well, sir, it says this, but is there an equitable issue? No. Is there an extreme moral issue? No. Then court is adjourned. Whatever the instrument says, do that. Now I'm just saying that briefly, but that's not as simple as that, but that's the essence of it as far as the courts are concerned. Okay? Does that mean they won't listen to the petition? Of course, they listen to everything. But oftentimes they have their decision long before the petitions are done because the courts are considering exactly what I'm telling you. These guys know that they should follow the rule of the trust, and they know that what they're presenting us is not ultra vires so serious that we have to make any change outside the trust instrument. But if they choose to make their petitions, says the judge to himself quietly, herself, I'll listen. After all, what else do I have to do today other than listen? Even they already know what they're going to rule sometimes. Okay. All right, and then finally, she said that, what did she say? What was the final point that Melissa made? Anybody? What was her final point? Nobody remembers what Melissa's final point was? Sorry, not Melissa.
Janice?
Janice. No, nobody answered. Sorry. Yeah, Janice's final point. What was her final point?
That the administrator have to to ensure that all the legal formalities are in place so that the amendments are recognized and executed.
Absolutely. All right, so once the amendments are done, may not necessarily stop there. You have to make sure that all the subsequent things that need to be done are done. Any recordings, any adjustments, any legal ramblings, and make sure all of those are done, even after the amendments are done. Okay. By the way, Janice, interesting that they left the answer to you. So Janice read it left. All right. Sorry, just being the devil's advocate. Does anybody know what the devil's advocate means? No? Okay. Well, that's a little off the wall homework. If you're curious, check it out, see what the devil advocates means, if you're not sure. All right, last but not least, let's look at our self-assessment questions for Unit 9. Anybody had a chance to attempt it? Yes?
Yeah.
Okay, great. Number 1, who has overall responsibility for the administration of the trust under the guidance and oversight of the trustee?
Trust administrator.
The trust administrator.
Trust administrator, notice, under the guidance and oversight of the trustee. So whoever is in charge of the trust company, the managing director, CEO, whatever, the administrator clearly falls under that person, see? And so the administrator answers to the CEO of the company. A lot of people think that the trust administrator is the CEO, but that's typically not so. The trust administrator falls under the CEO of the company. Number 2, the
I
exercise
have
of
a question, sorry. So
no problem.
the trust administrator is like the trust officers, right? Or they come on,
You might say the trust administrator is like the trust officer's senior or boss.
Mm,
You follow?
okay.
In
So
other
then what
words,
would you call the
that's-
trust officers?
Well, they're Indians and facilitators and, you know what I mean? They're especially, like, it's like this. It's like if you work for a law firm, the head of the law firm is the CEO of the law firm. You're a lawyer at a big time law firm. You're one of the lawyers that help the firm get things done. Trust officers are like that. And then the trust administrator is like the person who's in charge of the trust activities of the trusteeship. So, because sometimes some trusteeships may have something else going on, or they have adjunct sections outside of the trust itself. And so the trust administrator, for example, let's say you have the legal department. The legal department may not necessarily fall under the trust department. You follow? They're just there to give legal advice to the trust department and to the CEO. You follow that? So they don't really fall under the trust department. The trust administrator is the person at the top of the heap in terms of making sure that the trust functions are done adequately and properly.
So when they talk about delegating responsibilities, the trust that they could delegate those to the trust officers, that would be a part of
Yeah,
that.
who can
or-
delegate?
Okay, so
Yeah, who can delegate?
the trustee can delegate certain responsibilities, but not the liability, right? But when they delegate, like, no.
No, yeah, you're right. That's what I
Oh,
mean.
okay, so like when they delegate, let's say they delegate some of their responsibilities, will it be to the trust officers in that
Then who
aspect?
delegates the responsibility?
The trustee or the
Okay.
trust admin-
Okay, I got you. Here's typically how it may go, not necessarily in that order all the time. Typically, the professional trustee, it would be the owners of the trust company, okay? And the owners of the trust company, whoever they might be, will have a CEO at the top. The CEO will then appoint a trust administrator. So really, the CEO is delegating, as far as trusts are concerned in that company, the CEO is delegating that responsibility to the trust administrator. The trust administrator will in turn delegate a bunch of responsibilities to all kinds of people, including trust officers. And they all work on behalf of the administrator in administering the trust. See how that works?
Okay,
You sound like you still have a question. Raise it,
yeah.
raise it.
Yes and no, because I just was trying to understand, okay, like, so for JP Morgan, they're the trustee, right? When they take on a trust, so they're considered the trustee, right? Okay,
Right.
so
Now,
the trust
before you
officers,
go- yeah.
okay, go ahead. Go ahead, what
No.
you gonna say?
JP Morgan would then be the trustee, correct?
Right,
Now your
Mm.
question.
all right. So the trust administrator, because we going down now, so trust administrator would be you're saying the managing director or the CEO or the senior trust officer.
As determined by the trustee, which is JP Morgan. Because
Okay,
remember,
so.
every trustee have their own setup,
Mhm.
but typically JP Morgan, the company, the trust company, would
Mhm.
typically appoint a trust administrator. What they call that person might be different things, but
Mm.
typically that trust administrator will be the person who will run the trust affairs for the entire trust company. Now, does that mean that the administrator could be the same as the managing director of JP? Maybe. Or JP Morgan might have a managing director that's responsible for the overall business of the trust, including trust administration, because there might be other things going on. And the trust administrator will then be hired to handle all the trust issues.
Mm.
Do you follow?
Yeah, interesting.
So
I
it
got you.
depends on the size of the organization and how they want it structured. But typically, whoever is designated as the administrator, whether it's the managing director or a separate person, that person's job will be to be responsible for the entire trust department, trust activities,
Okay.
period. Yeah, absolutely. So, for example, any trust matters that come up, the trust officers and others who work in the trust department, the trust accountants and all that, they will not go to legal. unless it's a legal matter. They will go to the trust administrator and say, here are the results of what you requested. Here's the concern we have with regards to this legacy trust. And
Okay.
that's where the administrator comes in, exactly.
Okay.
Again, bear in mind, now that some organizations will structure things differently, but you'll know by the function that who the trust administrator is, for sure. And if you work for a company, a trust company, and you're not sure, which is okay, because a lot of people work for trust companies and they don't even know that there's a trust administrator, because they don't even know what trust administrator is, even though they work for a trust company. But
Right.
now you guys have been bold enough to get out of bed and get information, see? So now he said, oh, trust administrator, I'm going back to that bloody job and find out who our trust administrator is. How about that? Kind of like that. And then if you're really curious, you'll find out. Just ask, who's the trust administrator for JP Morgan or Scotia or CIBC or whatever, and they'll tell you, hopefully. Okay, because if you're a really junior person, somebody might, well, why do you want to know? Which is, of course, a ridiculous question if you work in a trust department. Even though you might be like the smallest fry in there, that shouldn't be any reason why you shouldn't ask who the administrator is. Everybody should know who the trust administrator is, who's functioning in that position. See my point? And whoever it is functioning in that position, they are subject to everything we talked about this morning. That's really the key. Okay? So if you're not sure about who's the trust administrator in your organization, you might then want to take that curiosity on Monday and like go on a little Sherlock Holmes thing and see like, make some inquiries. That might be interesting. And if you find anything interesting, I'm always interested in curious stuff. You might send me a text or something next week and say, wait a minute, I know our sessions are over, but I was roaming around on this trust thing and something is this really, see, like that? And feel free to do that. Okay, that's how we find out things. All right, number 2, the exercise of discretion by the trustee is normally shared by members of a blank or professional trustees whose deliberations are often documented in trust instruments which do not become the trust property and are not required to disclose to the beneficiaries or a court of competent jurisdiction. And the blank is?
Trust committee.
Yeah, the trust committee. Okay. If it's a little small trust, there's usually no committee. The senior trust officer or the trust administrator, there's one. Again, for small trust relationships, there may not even be a trust administrator, just a senior trust officer. See, there you go. The senior trust officer may be designated a trust administrator, because we can designate anybody who has the skills and experience in trust as the trust administrator, so long as we're satisfied that they can carry out all these things that we just talked about. Okay, don't designate your friend in accounting as trust administrator if they know anything about trusts, even though that can happen. Stranger things have happened. All right, number 3, trust administrator must also be blank of the terms and the parties to the trust.
Knowledgeable.
Yeah, knowledgeable, that's the key. Number 4, additionally, trust administrators should understand, be knowledgeable of the blank, governing duties and trustees and the administration of the trust generally.
Trust laws.
Trust laws.
Yes, trust laws, by all means. Other than the instrument, then we have the laws, then we have the beneficiaries, and then we have your honor. All right, number 5, trust administrators encouraged to blank and to familiarize him or herself with the beneficiaries, entitlements, duties and powers, etc., appointment of agents, trustee investments, and the overall terms and conditions governing the trust.
Review the
Agree.
trust instruments
Yeah,
and documents.
review the trust instruments and related documents, whatever they might be. The whole idea is, if you're an administrator of a trust or trusts, you need to be familiar. You may think it's an automatic thing, it's not. You'd be surprised how many administrators, quote unquote, are not familiar with some things they should be familiar with. Number 6, Section 80C of the Trustee Act 1998 allows beneficiaries to blank trust deeds, accounts, and other trust documents excluding trust minutes.
Inspect.
Inspect.
Yeah, inspect them. Why would beneficiaries want to inspect these things? Trustees, accounts, other trust documents. Why would they be interested in that?
To make sure the trustee is doing what they're supposed to be doing.
Absolutely. They're not all just nosy and greedy, even though many of them are nosy and greedy. Because sometimes they want to try and find out what's going on with other beneficiaries, see? To see if someone who's getting more who's getting less. Yep, that goes on too. And depending on what they discover, all hell breaks loose for the administrator. Because now a beneficiary walks and says, how the hell can Suzette get $100,000 more than me in your bloody discretion? What discretion did you use anyway to give her more? Do you like her more than me, Mr. Administrator? Sort of thing. And then if you can't get a result, it might even end up in court with a petition that this guy using his discretion to enrich one beneficiary over the other. And then you have a legal battle again. And I say again because legal battles are going on all the time. Lawyers love trust issues, especially contentious trusts. Some lawyers only deal with contentious trusts. That's all they do. They don't even want to notarize a document. They're so busy with contentious trusts getting richer and richer from contentious trusts. Okay. Number 7, the trust administrator must also take special care to ensure that amendments to the trust instruments are done in accordance with any blank reserved within the trust instrument to so and the other method prescribed.
Express power.
Yeah, express powers. Meaning whatever powers in the instrument, they have to be in writing. Can't be that the protector said so. The protector is my friend whom I trust said so. Sorry, that's not gonna work. But I trust him, he's a pastor. Who gives a flying fish? Okay? Sorry, not to discredit the pastor, just make sure we understand that it has to be in writing. That's really the point. Doesn't matter what the designation of the person is. I just use pastor to make it a little more interesting. Okay? Are all pastors honest? Sorry, it's not a trick question. It's a real. So I'm not answering that one. Let me answer for you. The answer is no. Okay? Designations don't make character. Characters make designations, okay? Just in case you wanted to go with a trick question. That's why even with the trustee issue, it has to be written, no matter what the designation is. Who said it? Number 8, the amendment to the trust instrument must be blank and blank.
Clear and unequivocal.
Yes, clear and unequivocal. Okay? No doubt. Number 9, trust administrators should not only protect and preserve the trust property, saw that at the beginning, due to propose amendments to the trust instrument, I just threw that in, but also ensure that the blank and blank of the trustee are not adversely affected.
Legal protection and remuneration.
Yes. In case you guys haven't picked up on those 2 clauses there, what it really means is, sure, go ahead and make amendments to the trust instrument. But Mr. Whoever wants to make the amendment, make sure your amendments are not going to affect any legal protections that I have as trust administrator, trustee, and my money. How about that? I know. I kind of made it dramatic so I could remember. But it is a very serious issue. Sometimes amendments are being made that are not in good faith. And sometimes if the trustee is not looking keen or administrator and observant, the amendment might impact their legal protection remuneration. Sometimes if the trust administrator is not keen on top of their game, an amendment can change the legal protection remuneration without them even realizing. My. So you thought it was just distributing money to beneficiaries, huh? This trust business is much more than that. As you will see, as you get deeper and deeper into the administration of trust in any capacity. And finally, number 10, not only should the trust administrator ensure that the blank to effectuate the amendment are recognized and executed, but he or she must also take action in carrying out any and all the duties to assist the efficient functioning and effective administration of the trust subsequent to the amendment. And the blank is?
Legal formalities.
Formalities.
Yeah, make sure all the legal formalities are in place. Don't do all of that, and one of the formalities is that the document needs to be notarized, and you don't get it notarized. Or you let your spouse notarize it. If, let's say you're a trust officer and your spouse is a JP or a notary public, should they notarize your document?
No, they
Your
should.
spouse,
No.
you're a trust officer. Your spouse is notarized. Honey, can you notarize this? Should you do that?
No.
Why shouldn't you do that?
Conflict of interest.
Yeah, it's a conflict of interest. Absolutely. And even if you don't think so at the time because you're doing everything honestly, you may be doing everything honestly, but that will not change the perception of a conflict of interest. And if that gets to a beneficiary and they discover that you let your spouse notarize that document could be in perfect order. A particular beneficiary will still take it to court and question your intent, your integrity, and your intentional conflict of interest behavior, especially if the beneficiary doesn't like you. And you might say, well, what does like me have to do with it? Like me has to do with a lot of things everywhere. Unfortunately, sometimes. But sometimes it shouldn't matter if somebody likes you or not. What is right no matter if somebody likes you or not. It doesn't always work that way. Unfortunatamente. Okay, and unfortunately it doesn't. All right. So ladies, that brings us to the end of our session. How many more units do you guys have after this one?
4
4 more and then you'll be
or
done.
5, eh?
Now, 4 or 5 more. Now, from what I gather, this is trust and administration stage 1, is it?
Yes.
Yes.
Yeah, which means that there is a stage 2. What I suggest you do is once you've suffered through this one, sorry, I just said suffer so you could remember. When you've gone through this one and passed your examination, as soon as part 2 rolls around, don't wait, don't procrastinate, don't say you'll do it when you feel better, when you get money and all that stuff. Take an aspirin, borrow the money, whatever you need to do, and get it behind you so that you can move on to the next level, okay? But you're certainly moving in the right direction. Part 2 will give you a whole lot more stuff for sure on how trusts are administered from day to day, and will certainly, if you think this information has been insightful, I can assure you part 2 gives you some more interesting and exciting information in the life and world of the trustee and all of her or his foot soldiers, who are the trust officers. Okay? That's why we have an organization where there's a trust company, we have junior trust officers, senior trust officers, super senior trust officers, VP, and all kinds of different stuff, because trust business is a significantly huge business depending on the size and type of trust you administer. All right, so that brings us to the end. Does anybody have any other questions that you'd like to raise before we're done? Fantastic. You guys have been amazing. You raised some very, very good questions that I'm sure was very helpful to your colleagues in the room. And I wish you every success, not only in your examinations, but as you go forward with your trust future. Okay. All right. Take care and be safe out there.
Thank you.
Thank you.
Bye-bye.
Pleasure, my
Good
friend.
afternoon,
Bye.
everyone.
Take care, ladies.